There we go. All right, cool. So we left off right here, paragraph 8. Items included and excluded from the sale. So what do you get with a house? What comes with a house, right? That's basically what we got here. So first and foremost, paragraph 8A, notice to the buyer and seller. It says here that everything that is listed as being included or excluded in the MLS, flyers, other marketing materials are not included in the purchase price or excluded from the sale unless specified. Okay. So whatever you guys discuss with agents verbally on a showing or something that's in the MLS or on a flyer or somewhere you see something is included or is not supposed to stay with the property, maybe in the listing agreement, none of that matters unless it's in the contract. It must be in the purchase agreement. Okay. This document dictates all of the terms for our sale. Okay. I'll tell you a quick story that you may appreciate. I did a deal with another agent and I was out of town. So my partner went and showed the house while I was gone. And I got the offer written up. I was out of state actually and sent the offer over and we got it accepted. Okay. And when my clients went to see it with my partner, they were at an open house. So, we wrote up our contract, submitted the offer, got accepted, closed the deal. Actually, right before we were closing, for some reason I was out of town again, just randomly at the beginning and the end of this escrow. And the sellers were there. And my partner walked the property with our client and she asked just, casually, how's the move going? And they said, great, we just got to come back and pick up our washer and dryer and we're all set. And we had asked for microwave was built in. We asked for the washer, the dryer, the refrigerator, the stove stayed. They're all the same utilities. They all matched, or same appliances. They all matched. And so my partner was like, wait a minute, I think those are supposed to stay. So she called me and, I verified in the contract to make sure that we did indeed ask for everything. And we did. And I called the other agent and the guy said, we told everybody at the open house that the appliances were not included. And I said, I was not there at the open house. I sent you a contract and you should have reviewed that. And he realized it was his mistake. And guess who got brand new appliances paid for by their agent, right? So he helped them go buy another house. And he basically was very upset with me because I snuck something into the contract. I mean, it's right here in front of you. All you got to do is read it. He should have been mad at himself for not looking at his own contract. But anyways, he ended up basically selling that listing for almost zero commission because it was friends. He was already reducing his commission, and then he had to go buy them all brand new appliances in their next property. So, yep, make sure you read, make sure you understand. Verbal stuff that's in, the MLS or whatever, none of that matters. It's what's in here, okay? So what does automatically get included? Well, that's what paragraph B, items included in the sale. So basically, the first thing is all existing fixtures and fittings that are attached to the property. So things that are like screwed down, bolted down, attached to a property are what comes with. And then there is paragraph 2 that goes through a little bit deeper on some of the things that gets more defined, right? So we have existing electrical, mechanical, lighting, plumbing, heating fixtures, ceiling fans, fireplace inserts, gas logs, grates, solar power systems, built-in appliances, window and door screens, awnings, shutters, window coverings, et cetera, et cetera, et cetera. Okay, so all these things are considered attached to the property. And then towards the middle of that paragraph, we have the ability to check off whether we're going to ask for the stoves, the refrigerators, or washer and dryers. And each of them have a check box next to them that you can check. And then they have the word except. Sometimes people have multiple refrigerators or freezers. Maybe there's a guest house with 2 sets of laundry, washer and dryer, et cetera. So this is where you can ask for those items. Okay. If the purchase agreement, you want anything else included, you'll add it right here in paragraph 3, the following additional items. Okay. So you would just type in what it is that you are asking for. And if it doesn't fit in this one little line, it'll automatically include what's called a TOA, a text overflow addendum. So another form that will have more room to continue to write. Okay. It also says here that existing integrated phone and home automation systems Okay, so that's interesting. Does that include a smart home device? I think most people would say no, because those are, just plugged in. They're not necessarily attached to the property. But what about security, right? Well, we have up here security systems and alarms. So those would be included. Now, I've had this come up numerous times. What about like the Ring doorbell and things like that? I think most people would say that, yeah, that is part of a security system. It's, screwed into the doorbell and is attached to the property. Okay. It also then goes on to talk about leased or liened items and systems. Okay. So first of all, the seller has to disclose to the buyer whether any item in the property is leased or not owned by the seller. So what might that include? Well, I think you guys have seen before, like solar panels on the roof, or sometimes you may have one of these hero or PACE loans where there's a lien against the property for companies that have come in to do work like energy efficiency, new windows, things of that nature, and it may be a lien. So this talks about the fact that the buyer, it's subject to their review, right? The buyer is supposed to be delivered to them written materials such as the lease, the warranty, or anything else concerning whatever that item is. And then it's contingent on the buyer's ability to assume a lease or accept a property with a lien or encumbrance. Okay, it's a contingency. People seem to think that there's only like 3 contingencies in the offer. The inspection, the appraisal, and the loan. There's actually quite a few different contingencies, this being one of them. So, you always, when you're taking a listing, you always want to ask, if you go to the house and you see solar panels or new upgrades, do you have liens or did you get a lease for any of this stuff? And if so, do you have any documentation? What are the terms? Okay, et cetera, et cetera. So we want to know about that. And then everything else that comes with the property, the seller represents that they are owned by the seller and will be transferred free and clear, except for anything that was disclosed in the leased or liened items section. Okay. So that's basically the majority of what comes with a house. And then lastly here in paragraph C, items excluded. Basically it says here audio and video components such as flat screen TVs, speakers, etc. Okay. So it says here that even if a TV is attached to a wall mount to a wall, the TV is not included. And the default in the contract here is that the brackets that are attached to the walls will stay with the property. Okay, so if there is a flat screen mount on the wall, the mount stays, the TV goes, okay? And you have the option to check a box here that says, or we're taking the, or we want the mount removed and repaired, but it will not be painted, okay? So that's basically that. Okay, that is everything that comes with a property. And then everything that is not, fixed or real property is considered personal property. And the expectation is that it will be removed from the property. Okay, and we'll look a little bit later when we look at the condition of the property where it discusses a little bit more about personal property being removed.
Hey,
Okay,
Nick.
yes.
So for those leased and liened items, let's say if it's something that the buyer doesn't care whether it's included with the house or not, can they
Right.
at some point negotiate and say, like, I don't want to take over your lease or your on this item, or how does that work out?
Yeah, so let's say there's solar panels, there's 3 years left on the lease. So the buyer could actually make as part of their offer that the seller pays off the 3 years. And that way it's owned free and clear afterwards. So that is absolutely possible. In this market, I'm not so sure that term is going to get accepted, but maybe. So yes, you can ask them to be paid off so that they're, free and clear.
Thank you.
Yeah, of course. Any other questions about what comes with a house? Okay, you guys know, feel free to interrupt me. I tend to just keep talking anytime. All right.
Hey Nick,
Yo,
can you go over that hero loan thing again?
the which one?
The hero loan?
So if they're, the Hero and the PACE programs, which I think you can't even get anymore, I think they were banned effectively. If they record a lien against the title to the home until they're paid off, basically. So,
Okay.
so it's a lien against the property, and the seller is supposed to deliver the property with no liens against it, so that it needs to be addressed. So it either needs to be assumed by the buyer, or it needs to be paid off by the seller. It's all a
Okay.
negotiation.
Okay, gotcha. Thank you.
You're welcome. Okay, let's look at paragraph 9, closing and possession. And boy, let me tell you, this is definitely one of the biggest issues I see happening. Aside from trying to get an offer accepted for a buyer, possession of a home is very challenging. I think I saw in some of our social media groups where there were some people that bought a property. I think it was maybe in San Bernardino, Riverside County or something like that, but they've owned it for over a year, but the previous owner hasn't moved out. There's no eviction, so they can't get him out. And they're just paying for a home they can't even occupy, and there's really no options, okay? I have some thoughts around that if you are trying to work with a possession. I'll tell you what they are in a second. So the default is that the buyer is going to occupy the property. They do intend to. If they don't, there's a checkbox. The default for the purchase agreement is possession to be delivered to the buyer at 6 p.m. on the date of close, period. Okay? That's when possession's to be delivered. Now, if you know the seller needs more time, they need to rent back or they need to stay in the property and you're going to give them a free rent back, let's say for 15 days. Okay? We're going to give them a couple of weeks and a day. Then the next paragraph here, paragraph C, says, if the seller's staying in possession after the close of escrow, the buyer and the seller are advised to sign a separate occupancy agreement. Okay. So there's two of these. There's the CAR form SIP, seller in possession, and that would be used for less than 30 days. Okay. Less than 30 days, you use the SIP. It's it's essentially what we call a licensing agreement. They have a license to remain in possession, not really a lease. Okay. If it's for more than 30 days, 30 days or more, you would use the RLAS, residential lease after sale. And this is basically a full-blown lease agreement, like a 7-page lease agreement. Okay. Now there's some pieces of advice here. Parties are advised to consult with their insurance and legal advisors for information about liability, damage, injury, etc. Okay. And the buyer needs to find out from their lender about the impact of seller's occupancy on the buyer's loan. If a buyer's getting a government insured loan, like an FHA or a VA loan, the lender in most cases will not let the seller stay in possession for more than 30 days, okay? Because they're buying it as an owner occupancy. And so the intention is that they are going to move in. So if you're working on that with a federal insured loan, you want to check with the lender about that, okay? As far as these RLAS and SIP goes, these occupancy agreements, the biggest piece of advice I can give you right now is if a seller is going to stay in the property after the close of escrow, you should always get a substantial deposit to be put into escrow and released to the buyer if the seller does not vacate on the agreed upon day. Okay. Then you got some skin in the game. Then the seller has a reason to get out, So I would say we're leaving $5,000 in escrow until you leave. As long as you leave on time, you get your $5,000 back. But if you do not, the buyer gets it to cover, rent, their loan payment and maybe an eviction. Okay. Now, on the other side of things, tenant occupied property. You've really got to be careful with this, depending on what you want to have happen. I see this happen where, a buyer makes an offer to buy a property. The seller says, we'll serve them notice, but we're not going to completely get them out of the property. You have to do that after the close of escrow. When you have a term like that, be very, very wary, because remember, the only remedy to remove a tenant from a property is a unlawful detainer, which is an eviction. Okay. The unlawful detainer, that's the legal name of evicting somebody. If they don't leave, you have to do that. And technically, you're supposed to be able to do an eviction if it's not COVID related. But basically, if the courts aren't taking the cases, they're just not going to do it, even if it is non-COVID related. And in fact, that news article example I told you, the owner staying in the house has nothing to do with coronavirus. They're just staying in the house, and the buyers can't do anything because the county is just telling them we're not doing any evictions at all right now. So good luck with that. Same rules apply for a tenant. You need to, get some sort of a deposit or have some sort of compensation or money that's held in escrow for them to vacate on time if everybody agrees to that. Okay. Now a tenant can agree to leave a property, right? Or break a lease, but they have to agree to it. We do have a form called a cash for keys agreement that says, hey, if you get out, we'll give you a couple $1,000 to help you move. After you leave, we'll give you the money if you're out by a certain amount of time. So you can always negotiate that. Okay. And then basically the last two parts of this are just talking about assigning any warranties that they can, give them copies of the warranties if they're available, and then provide the keys, right? Passcodes to unlock doors, operate locks, mailbox security systems. And then it just mentions briefly that if it's an HOA, the buyer may need to put a deposit down to get a copy of whatever keys are necessary to access the building. Okay.
Nick, can I go back to the tenant occupied for just a second?
Yep.
So they said that you can do the eviction, like if once you get into contract, you can do the paperwork to evict. How successful has that been lately, especially with, no one looking at going to trial or anything?
It's
Are
just, yeah, I mean, they're just not taking the cases at all. That's the problem. So, in normal times, if a tenant's not paying or whatever, you file the unlawful detainer, they'll have to get out. The sheriff will come out and forcefully remove them and their stuff. But since COVID has put an eviction moratorium, even if it's not COVID related, most everywhere is just saying we're not doing any evictions at all right now, period, no matter what.
Okay. Yeah, because I remember, I think it was sometime last year, there was that eviction court class that one of the girls in LA did, and she said something about the only time you could evict was if someone were to put in an offer on a home, and then that's the only time they can serve an eviction letter. But does that really not? Do they really still not leave?
So basically, there's reasons why you can, and so that's not necessarily an eviction. That would just be serving notice to say, hey, we're going to sell this property to a buyer that's going to live in the property, and that is they call it a just cause. That is a reason to serve notice. But as far as I know, and especially in LA County, you can't even serve notices for people to leave, whether it's just cause or not.
Okay.
So, basically to get a tenant out forcefully, through the legal channels it's just probably not going to be a possibility until I think June is when the next moratorium expires.
Okay,
So,
perfect.
just again, any tenant, any seller, remaining in possession, you've really got to be thoughtful about how you negotiate, and again, leave money in escrow or, use cash. It's the biggest bargaining chip that we have, really. So.
Perfect. Thank you.
Yep. All right. So that is possession. Okay. Tenant, seller staying. If you want the tenant to stay in possession because you're buying a rental, then you just check the box and use the form, the TIP. What happened? I'm losing my contract here. That's weird. Hold on. Zip forms is bugging out on me here. Let me get back to where we were. Okay, 1 second. Zip forms is not playing nice right now. Okay, we're gonna pivot real quick. And we are just gonna use a real contract that I was reviewing earlier for our agents. Hopefully you'll be able to see this. It's a little bit smaller on the screen, I realize. Where were we? Okay, so we were right here. All right, let's keep going. So that's our possession. If you have questions about how to fill out the SIPs or the RLAS or like getting people out or whatever, just call me and let me know, and I can always, game plan with you, like what the scenario is and what the easiest way to get people to move would be. So paragraph 10, statutory and other disclosures, including lead-based paint and cancellation rights. So the California Civil Code has statutory disclosures, which include a lead-based paint disclosure. And it also includes things like a transfer disclosure statement, the TDS, natural hazards disclosure statement, which looks for things like flood, fire, earthquake, and seismic activity, and then a few other things that are noted on either the SPQ, the seller property questionnaire, or the ESD, which is the exempt seller disclosure. So we'll go through the disclosures in another class, but these are statutory, meaning they're required per California law, and they have cancellation rights. Okay, I can't highlight anymore, sorry, but they have cancellation rights, meaning if any of these items are provided to a buyer electronically, meaning via email, the buyer then has 5 days to review one of these disclosures and decide if they want to move forward. And it's a requirement, and it comes with a cancellation right. Even if you make an offer with no inspection contingency or investigation, even if you remove that contingency, once you receive the TDS, you get 5 days to review and you still have your cancellation right. And that's something that you can't waive. It says right here, note to buyer and seller, waiver of statutory and lead disclosures is prohibited by law. And here's another thing that's super important. On the seller side, when they do the TDS, you guys also have to do a visual inspection, the AVID, the AVID, Agent Visual Inspection Disclosure. If you take your TDS, and the section on page 3 is where you would either write your disclosure or check the box that says you're going to provide the form, the AVID. If you don't give that to the buyer, and then you give the AVID a week or two down the road, it re-triggers the 5-day window for the buyer to be able to cancel. So when you guys open escrow, make sure you're getting your visual inspections done in a timely fashion, right? The seller disclosures, if it's your listing, the seller disclosures are supposed to be delivered within 7 days of opening escrow. That should include your AVID on the seller side. And then when you return them from the buyer to the seller signed, if you're representing the buyer, your AVID should be in there as well. Okay. So that's a little bit about statutory and our visual inspection. It does note here that unless exempt, the seller will provide a transfer disclosure statement and a seller property questionnaire. Okay, so TDS means you get an SPQ as well. Sometimes the seller is exempt from providing a TDS, in which case there's a one-pager called an exempt seller disclosure. So who's exempt? Essentially, most entities are exempt. Trusts, corporation, LLC, those types of entities. Although I would say this, just because you're an entity, it doesn't mean you can't disclose known material facts and defects. And I'll tell you this, I see this happen all the time with flips. The seller will be a flipper who has a corporation, and they'll say, oh, we don't have to give you this TDS because we're a corporation. And the reality is, if anyone knows in depth what's going on with the house, it's somebody that flipped it, because they're in it, right? They are getting receipts from their contractors. They're looking at the property when it's under construction. So if anyone knows what's going on, they do. So, if you ever represent a person flipping a property, you should tell them their standard of disclosure should be higher than anybody else, because that is something that can result in lawsuits if they don't disclose, and it'll be pretty much a slam dunk case too. All right, paragraph 6 here talks about if the seller becomes aware of any sort of new material fact or defect, they have to provide a disclosure update in writing. They have to amend the disclosure. And if the buyer is made aware of new information, the buyer has an additional 5 days to cancel the agreement. Okay. So any new information disclosed to the buyer that is a material fact or defect the seller becomes aware of re-triggers a 5-day window for the buyer to cancel escrow. Okay. So the last few things noted here, we're going to give the buyer a copy of natural hazards, an environmental hazard disclosure booklet Okay, the NHD's companies usually give those. There are environmental hazards, earthquake booklet, which includes toxic mold and what else is in there? Lead, mold, earthquake. It's all in the same booklet. And your TCs, generally speaking, deliver those to the buyer with a signature page for receipt. C talks about withholding taxes. I'm not going to go too deep into this, but it does say the seller is going to provide escrow or another person a document that shows that they're not required to withhold some of their money when they sell a property. You see, when you sell a house, you have to pay taxes. And in some instances, you may have an exemption for not having to pay taxes, right? There are tax codes like a 1031 exchange, or when you own your personal residence for more than 2 out of the past 5 years, the 121. So you have to provide an affidavit that says you either are or not required to withhold, and it's the buyer's responsibility to make sure the seller withholds taxes if applicable. Okay. Usually escrow handles most of this, but you just want to make sure you get that document and it's in your file. Okay. D is for Megan's Law. This is for public sex offender notification, and there is a website that they can go to. A buyer can go to look up if anyone is in their neighborhood. Notice regarding gas and hazardous liquid transmission pipelines. Underneath the ground are all these natural gas pipelines and so on, and there are maps that you can see at this site if you want to maybe put in a pool or something or do some work. Okay. And then lastly, when it comes to statutory disclosures, it talks about condominium and planned development. So the seller has to disclose within 7 days if the property is a condo or is located in a PUD, a planned unit development, or other common interest subdivision, basically anywhere that has a homeowners association or property management. Okay. So they got to tell us right away. And then the seller is obligated to request from the homeowners association a whole list of documents that they're required to deliver per California Civil Code. And this includes things like disclosures of any anticipated or pending claims or litigation, like it's the HOA, statement regarding parking and storage, at least 12 months of homeowners association minutes from their meetings so we can see what's being talked about, contact info for all the HOAs and property managers, whether there are already private transfer fees. Some buildings have fees every time a property sells that go back to the original developer. Pet restrictions or fees, smoking restrictions, and then anything else that's required by law to provide. Okay. So we've got to provide that, or the seller has to order it within 3 days. I generally will order it like right up front. That way I have it like right when I take the listing, because sometimes that stuff takes a month or more, and they'll charge you crazy fees to put rushes on some of this stuff. So you don't want to be involved in any of that for sure. You want to try to get that as early as possible and not put your seller in a burden financially. All right. Number 11 and 12. So this is where we start talking about condition, and there's some great information in here you guys need to be aware of. Okay. First and foremost, the condition of the property. It says, unless otherwise agreed in writing, the property is sold as is in its present physical condition. So all homes in California that use the CAR contract, the default is that the home is sold as is. When you're working with your buyers, it's so important to read that sentence and show them in the contract where it exists. It goes on to say, sold as is, subject to buyer's investigation rights, meaning the buyer has the right to conduct all their investigations as dictated in the later paragraph. And the last part of this, or the second last part, is that the property is to be maintained in substantially the same condition as on the date of acceptance. Okay. So what does that mean? Well, you got to maintain it and keep it exactly as it is. I know Stacy and I were talking about this earlier. So here's where it says we need to maintain it. So they can't just let the property fall into disrepair or not do anything about any damage that may occur. Okay. Here's another part of this. All debris and personal property not included in the sale shall be removed by close of escrow. So a lot of times I'll have agents concerned, like, are they going to take all their stuff? Well, the contract says they have to take all their stuff. Now, people don't always follow the contract, but it does state pretty clearly. So, if you have any concerns, you might reference this paragraph here in 11. Okay. So property sold as is, buyer has investigation rights. Seller has to, in all capitals, disclose known material facts and defects, okay, affecting the property, which includes, by the way, insurance claims within the past 5 years and any other disclosures required by law. B says buyer has the right to conduct buyer investigations of the property, okay, and based on the investigations, they have the right to either cancel this agreement or request the seller make repairs or take other action. Okay, so based on the buyer's investigations, if they don't like what they see, they can cancel or ask the seller fix, repair, or take another action, price reduction, credit, further disclosure, etc. Okay. And then lastly, in bold in paragraph 11C, it says the buyer is advised to conduct investigations of the entire property in order to determine its present condition. The seller may not be aware of all defects affecting the property or factors the buyer considers important. Okay. Property improvements may not be built according to code in compliance with current law or have permits issued. So it even tells us here, there may not be permits. You should investigate buyer. That's part of your due diligence. Speaking of permits, folks, you guys, you're not qualified to read permits, so you shouldn't be investigating permits. Your buyer can go direct to the city or they can hire a contractor to review what's on file at the building department with the city, okay? All right, let's keep going here. Buyer's investigation of property and matters affecting the property. Paragraph A is where the contingency for the buyer's investigation is put into place. Buyer's acceptance of the condition of and any other matter affecting the property is a contingency of this agreement as specified in 14B. You'll see in paragraph 14, this is where investigation timeframes, notice to perform, contingency removals, cancellation rights is all broken down. And then we'll see if we get through that today, okay? Now, it does give kind of a general list of what the buyer can look for. A general inspection, a termite inspection is noted in there, lead-based paint, any other matters based on the buyer inspection advisory, which is one of the last pages attached to the contract, reviewing the sex offender database, confirming the insurability of the property, including things like flood and fire insurance. If there's a tenant there, the review and approval of leases that the buyer may be assuming, okay? And then it notes here that the buyer shall not cause to be made or make invasive or destructive buyer investigations, meaning they're not gonna poke holes in walls, except minimally invasive testing that termite companies do. They carry around a stick with a little poker at the end and they jab it into the eaves and the rafters to see if there's any termite damage, okay? Now, more important information here. The seller must make the property available for the buyer investigations, okay? The buyer is gonna do their investigations. The buyer is then gonna remove the contingency of, attached to the investigations or cancel. And the buyer has to give the seller at no cost copies of all investigations obtained by the buyer, okay? So the buyer has to give the seller copies of everything that they have done on their behalf on the property. What else do we have here? Seller must have the utilities on, water, gas, electricity, and all operable pilot lights on for buyer's investigations and through the date possession is made available to buyer. Utilities need to be on for the entire transaction until the keys are given to the buyer to take over possession, okay? And then lastly, we have D, buyer indemnity and seller protection for entry. And basically it just says, the buyer's gonna keep the property free and clear of liens, fix any damage that they incur, and hold the seller harmless from any sort of liability claims, demands, damages, costs, etc. And then it says the buyer or anyone working on behalf of the buyer should be carrying liability insurance, workers' comp, and other applicable insurance protecting the seller, okay? So there is a note that the buyer needs to do that to cover the seller. All right. That is a lot regarding condition and investigation. Let's keep going. 13, title investing. So within the time specified, the buyer is going to be provided a preliminary title report, aka the prelim. Okay, here's where the buyer has the opportunity to review anything that is affecting title to the property. And so what a prelim is a commitment from the title company to give insurance for the title. So title is an insurance company, and they're insuring the title and the history, right? So basically they cover the day that the report is provided forward into the future, okay, to cover any claims that come from people that say they have ownership or anything else that should have been recorded against the title to the property. Okay, so that's what a prelim is. They'll have the opportunity to review it. It does say that the title is taken in its present condition, subject to encumbrances, easements, covenants, conditions, restrictions, rights, or other matters, whether of record or not, monetary liens of record, except which the seller is obligated to pay off unless the buyer is assuming those obligations, maybe assuming a loan or whatever. And then anything else the seller's agreed to remove in writing. So you're going to get a prelim, and it's going to have what are called exceptions. And usually you'll see, property taxes, supplemental taxes. You'll see potentially a deed of trust, which is a home loan. And that's generally it. You'll see some other things like some easements for like utilities, like in the back corner of my house, I have a telephone pole, which is on my property, but obviously I don't own that. So there's an easement for the utility company to come and access that whenever they want. So things of that nature you're going to see on there as well. And then only the exceptions that are monetary that the seller incurred will be addressed prior to close of escrow. Everything else is going to stay attached to the title. Okay, things you don't want to see, liens or judgments. Sometimes you see, spousal support, child support, notice of default, notice of sale. These are all, judgments or things that could affect the transfer of the title to the property. Okay. All right, let's see here. In addition to what comes in the prelim, the seller also has a duty to disclose to the buyer any other matters affecting the title that they're aware of, even if it's not recorded. Maybe someone else having an ownership interest or them owing money to somebody. And then at close, buyer will receive a grant deed conveying title to the buyer. Okay, that's one of the documents the seller signs, the grant deed. That's the official one pager that says, I hereby give you this property over to you, and they have it notarized. Okay. Buyer's also going to have the right to take title in different ways. Okay, there are multiple ways to take title. And it says here, the manner of taking title may have significant legal and tax consequences. Consult an appropriate professional. So what happens in certain scenarios, typically much of it is related to death or being able to resell the property. If there are multiple people on title, what happens? Is there a trust? What if it's joint tenants? What if it's tenants in common? What percent interest goes to who? What happens if there's two people on title and one passes away? Who gets the property? So there's a lot of things that come up on title. And again, you guys aren't qualified to advise on that. So usually the people that are qualified would be lawyers and accountants, because it's legal and tax. So many of your title reps will be able to walk through the differences, but I always recommend going straight to the pros and ask questions that they may have. Now it does say here also the buyer is going to be given a homeowner's policy of title insurance. So the seller typically will pay for a title insurance policy for the buyer to make sure no other person or entity has any sort of claims, whether that's monetarily or possession of the property. Okay. And that is title investing. A lot of good stuff there. Okay, let's see, 342. Let's go ahead and see if we can't tackle, paragraph 14. So this, if you notice, it's the entire page, and it basically is everything that has to do with your investigation timeframes, contingency timeframes, and so on. Okay, so we'll go ahead and buzz through a few of these things that are important. Okay. First of all, time periods may only be extended, altered, modified, or changed by mutual written agreement. So your buyer can't just say, I want more time to do my inspections. The seller has to agree to give them more time. Okay. It also says this, buyer or seller must be, cancellation or removal of contingencies by either party must be exercised in good faith and in writing. Okay. So good faith is an interesting word there. I don't know if, that's, I always say that if the law was black and white, there'd be no such thing as attorneys, right? Someone just read the contract and tell you whether it's right or wrong. But when you see words like good faith, I think that's where you have interpretation of what that actually means. Now, here's something to consider, and I see people getting in trouble with this a lot. A lot of buyers are writing offers, and they're being asked to remove their appraisal contingency. And so I've seen some buyers do that, and then the agent basically says, don't worry, if the appraisal comes in low, we'll use the inspection contingency to cancel. Or we'll say the loan contingency. We can't get the loan because of the appraisal. Well, guess what? Neither of those are good faith, right? Because you're using one protection to cancel for a different reason, right? So you got to be kind of clear and understand what good faith actually means, because you could get your client in trouble, okay? In fact, on page, I think 2, it even says there that you can't use the loan contingency to cancel because of a low appraisal. It actually specifically addresses that.
Hey, Nick, I had a question about extension.
Yep.
So my buyer, their loan needs about another week or two. How do we get that in writing? Is it just an email or is there a form?
There is a form. It's the ETA, Extension of Time Addendum.
Okay.
Yep. And so, yeah, definitely. Here's
And that's for
folks,
the buyer needing more time and the seller has to sign that to agree.
Yeah, it
Correct?
could be for anybody
Okay.
needing time. Yep. It could
Okay.
be the seller needs more time to close escrow, the buyer needs more time for whatever. So it has contingencies, close of escrow, and all the time frames are addressed in that one form. My advice to you as agents is really pay attention to the time frames that you've agreed to or your clients agreed to in the contract. And you really need to never let them go by without addressing them. So if you have a seller and you open escrow and the buyer has 17 days for investigation, then on day 15 or 16, you need to send a notice to perform to protect your client. Now, if the buyer needs more time, I'm in this market, I'm just saying, look, everything's taking a little bit longer. You know, lenders are busy. There's still some COVID restrictions and blah, blah, blah. So, but address it. So call the buyer's agent and say, do you need more time for your contingencies, or are you ready to remove them? And if you do need more time, we need to put it in writing. We will not let day 17 go by without either sending you a notice to perform to cancel, or force you to remove your contingency, or extend the time. And I see this happen all the time. Day 17 rolls by, seller doesn't do anything about it, and then they get upset. And next thing you know, you're like 30 days in escrow. And then, other agents call me. Can you help me with your agent? Because they're supposed to remove their contingency and it's day 35. And I'm thinking in my mind, did you send a notice to perform? Like, what are you trying to do to enforce the terms of the contract? There's remedies for all this stuff, but people just don't do anything about it. And, I've had an attorney explain to me like this: if a time frame expires and no one does anything about it, basically that means that all parties are agreeing to allow more time. So you can't have a seller get upset later on because the contingency wasn't removed in time, but the listing agent and seller never asked for an extension or a notice to perform to remove the contingency. So that's on you. I mean, you guys got to really monitor this stuff. So pay attention to your timeframes. Don't let them go by, especially with close of escrow as well. You have to get your close of escrow extension in writing. If you don't, seller can give a demand to close. And if you don't close, they can cancel. And if you've removed all your contingencies, they can keep the deposit. So, bear in mind. So what do we have here? Paragraph A, seller 7 days to deliver to the buyer everything they're responsible for: reports, inspections, etc. Paragraph B1, buyer has 17 days to complete all their investigations and review the disclosures and reports and whatever documents are provided and return them back to the seller. Okay. Now, B2, within the time specified, in this case 17 days, buyer may request seller make repairs or take other action regarding the property. Form RR, that's the repair request. Now look at this. So the buyer has within the 17 days the right to make a request for repairs or do whatever else they want, price reduction, credit, etc. That paragraph continues by saying the seller has no obligation to agree to or respond to the buyer's request. It references here that the seller doesn't even have to respond to requests, right? So I get this a lot. Well, we submitted a repair request, it's day 16, but they want us to remove our contingencies, but they haven't responded to the repair request yet. Well, they don't have to. They don't have to respond, okay? Nor do they have to agree. So if you're gonna negotiate repairs, you better get it done real early and don't let this stuff drag out in the contract. And in this market, with timeframes being shortened and contingencies being removed up front, I'm telling buyers agents, make sure your buyer is ready to bail on the deal at any given moment if they get a notice to perform and they're not ready to remove. I want them set up mentally to walk away from this deal if need be, if they're going to be not protected. Okay, so pay attention, monitor those timeframes. All right. 3, it says that the buyer will give a contingency removal or a cancellation within the timeframe specified. Okay, and if the seller doesn't deliver something on time, then the buyer has 5 additional days to review and then give a contingency removal or cancellation. So we talked about this earlier, but if something new is disclosed to the buyer, they have 5 additional days, even if the contingency was already removed. Here's another piece of this. Continuation of contingency. Even after the end of time specified and before seller cancels, if at all, buyer retains the right in writing to remove contingencies, cancel the agreement based on the contingency. Okay, so what that means is if on the buyer side, if day 17 goes by and there's no notice to perform, they don't give a contingency, they don't cancel, basically the contingency remains in effect. It continues until the buyer proactively removes, the buyer cancels, or the seller delivers a notice to perform, and then you have a choice to make at that point. Okay. All right. We had a deal actually just what was it? Just last week where the listing agent was saying that they were telling the seller to not give our buyer their deposit back, even though all the contingencies were removed. And it was one of those deals that just dragged on. It was past 17 days. And they emailed me and said, your agent's buyer didn't remove their contingency, and it's day 30. So we're going to, we're telling the seller to keep, 1 month rent for deposit or 1 month of their loan payment. And I'm like, no, you can't do that. You can ask, but we're not going to do it because you never removed the contingency. You never gave a notice to perform, right? Same thing, just not paying attention to the time frame. So be aware, okay? All right. Access to the property. This is a good one too. Buyer shall have access to the property for investigations for 17 days after acceptance. Okay. Whether or not any part of the buyer's investigation contingency has been waived or removed. So that's where they get the amount of time to access the property. But after 17 days, the seller doesn't have to give them any more access for any sort of investigations. Okay. There is a section here to remove contingencies with the offer. We typically never advise doing that. Seller's right to cancel. The seller can cancel if the buyer does not give a contingency or cancellation. The seller has to give a notice to perform. The default on that notice to perform is 2 days to remove the applicable contingency that's being discussed or cancel the escrow. If they don't, the seller can cancel and they have to return the buyer's deposit, okay? Contract obligations. So there are contingencies and then there are contractual obligations. They're basically handled the same way, okay? So here's an example. A contingency would be the buyer's investigation. right? They have the right to go and inspect, they have the right to review, and then they can decide if they want to cancel or not. A contractual obligation would be something like where the buyer has to deliver the deposit to escrow. That's not a contingency. There's no options or choices. They just have to do that within 3 days. Either way, if the buyer doesn't remove a contingency or perform on an obligation contractually, the seller can give a notice to perform. If the buyer does not perform, they can cancel after 2 days and give the buyer their money back. Okay. The notice to perform has to give at least 2 days to perform, or you can change, right? In my template default, I make this 3 days. I give my buyers an extra day to perform on their contingency removals. It cannot be delivered more than 2 days prior to the expiration of the contingency. So if we have a 17-day inspection, the seller can't give a notice to perform any earlier than day 15. Okay. All right. After review, after removal of contingencies, there's a paragraph here that says if the buyer removes in writing any contingency or cancellation right, then the buyer has been deemed to have completed their investigations, reviewed all reports, reviewed the disclosures, and they've elected to proceed with the transaction. And they're now assuming all liability, responsibility, and expense for repairs or corrections pertaining to that contingency. So the buyer has agreed to move forward and they're accepting the property as is once they remove their inspection contingency. We have a close of escrow paragraph. Basically says that the buyer or seller can cancel this agreement for failure of the other party to close escrow pursuant to this agreement. They have to deliver a demand to close escrow, the form DCE. So the DCE is very similar to the notice to perform. It's a demand to close. So it just says, hey, you've got 3 days to close, and if you don't, that party may cancel. Okay. If the seller needs to cancel after the buyer's removed all contingencies, they would have the right to retain the deposit. The DCE, the demand to close, cannot be delivered any earlier than 3 days before the scheduled close of escrow. So remember, just like I said with timeframes, contingencies, you need to monitor your close of escrow. Do not let the close of escrow day go by without getting an extension agreed upon. All right. Lastly, in this paragraph, and we'll wrap up for the day, effective cancellation on deposits. Basically, it just says, if either party cancels, then the deposit will be delivered to the appropriate party. If there's no contingencies, that would be the seller. If there are contingencies, most likely it goes back to the buyer. It does note here, release of funds will require mutual signed release instructions from the parties or judicial decision or arbitration award. So if you cancel the deal, the buyer and seller are expected to sign cancellation that discusses the disposition of the deposit. Escrow will not release a deposit without mutual signatures. So just because it may be clear in the contract that either party is supposed to get the deposit, if they don't, sign the agreement, then there's going to be a dispute. And that dispute would have to be addressed by mediation, potentially arbitration, or small claims court, depending if one party does not agree to, release a deposit to the other. It also does say here, a party may be subject to a civil penalty up to $1,000 for refusing to sign cancellation instructions if there's no good faith dispute. So this other agent that was saying, we want 1 month's rent or mortgage because you didn't, close on time or remove your contingencies. And I emailed back and said, absolutely not. And by the way, we can hold your seller responsible for $1,000. So not only will they have to refund the deposit, they'll lose $1,000. So please, let's just do the right thing. Ultimately, she finally did. Okay. All right, folks. That was a solid almost an hour of contracts. I hope you are all still awake out there. Do anyone have any questions that I can answer for you?